Hi everybody, my name is Brian Foley. I'm a criminal defense lawyer here in Conroe, Texas, and I help folks who've been accused of a crime in Conroe, the Woodlands, Houston, and that general area. Today we're going to be continuing our lecture series on the rules of evidence. Today's rule is rule number 103, still in that 100 series, the first two rules there. Today's rule is about how to object, how to preserve error when you have objected. And the first thing it says is that preserving a claim of error, that's the title of this rule pretty much, is a party may claim error in a ruling to admit or exclude evidence only if the error affects a substantial right of the party, and if the ruling admits evidence, a party must on the record timely object or move to strike and state the specific grounds unless it was apparent from the context. And so this is where you come into this idea that when you object to a piece of evidence, you can't just say objection and then sit down. You have to say what it is you're objecting to. Why is this a violation of the rules? You don't have to come out and say the rule number, although that's good and it'll probably get you brownie points with the judge, may even make them slightly more likely to side with you because it makes it sound like you really know, exactly how this rule operates if you remember the number too. But this rule says that you have to state why. You can't just say objection and then sit down. Now, if the statement is, let's say you have a police officer and he wants to say what the victim told him on the scene of the crime, right? The victim wasn't upset. We're not going to have an excited utterance exception to hearsay. It's just regular hearsay. If the officer gets asked the question, what did the victim say to you? Then you don't have to wait for that response as the attorney. You can say objection, hearsay, and that's probably enough. Just the word objection and hearsay. Now, as a matter of form, you're going to want to stand up. If you're a guy, you don't have to button the jacket again, but stand up at least, because if you're talking to the court, you probably need to be standing. So you stand up, say objection, hearsay, and that states the grounds. The context, when the rule here says if it's apparent from the context what the objection is going to be, you might be able to make an argument that it's obvious what the objection is going to be when you say, what did the victim tell you? But then again, you may have an excited utterance going on there, and you were just saying that they need to lay the proper predicate for excited utterance. We'll get to that when we get to the 800 series and rules of hearsay. But so Rule 103 is an interesting rule. Here's a couple miscellaneous topics about Rule 103. If you object while the jury is still in the jury room, then you don't have to object again when they get back. Okay, this is being able to object off the record, outside the presence of the jury. You don't have to keep restating these things. You can also, under this rule, ask for what's called a running objection. That way, if something's going on and you've lost this issue, you've said, the judge said, I'm going to let them talk about this. Maybe if it's the hearsay objection, you said, objection hearsay to the statements of the victim. And the judge said, no, I'm going to let this stuff in. We're going to get all these victims' testimony in. I think she was excited enough to account for the excited utterance exception. She was still under the emotional stress of the event that put her there, and she was talking about that event. I'm going to let this, this testimony in. Well, then you can say, Judge, may I have a running objection to that? And that way you don't have to stand up every time she says another word. Now, if you don't get a running objection, then the appellate prosecutors for the state might say that you waived your objection to that evidence because it came in later on in the trial. You objected to it the first time, lost. It came in later and you didn't even object. So they'll try to argue lots of different ways to parse down the issues that are present on the appeal. So that's Rule 103. And one other slightly interesting thing there is if we look at the very beginning of that rule, it says a party may claim error in a ruling to admit or exclude evidence only if the error affects a substantial right of the party. Okay, so is that really true, though? Think about it. If you're a criminal defense lawyer or prosecutor or anybody who tries cases in a court, have you ever made an objection that wasn't absolutely for a substantial right of the party? Probably. I think every time there's a leading objection, you're not supposed to ask leading questions on, direct examination of a witness. But if you ask a leading question and the other side objects, is that really a substantial right of the party? Probably not. But it's probably going to get sustained by the judge more times than not. So even though the rules have this language, it's pretty specific like that, trying to focus on the substance instead of the form. Us lawyers, we normally get down to the form, and we'll find ways to make sure that the rules are followed to the T, even if there's not a substantial right involved, like in a leading question. So there's Rule 103 for you. I hope you've enjoyed today's lecture series. If you're a lawyer and you want to count it as self-study, you could probably even break out your rule book, read the rule, and report it as self-study for your CLE. If you just hear regular folks out there wanting to know more about rules of evidence and things like that, I hope you've enjoyed it. We'll see you again next time for Rule 104.